Right, good evening everybody. Hopefully you can all see and hear me. I'm going to try and seamlessly change the screen share. Well, not quite so seamlessly, it would seem. So just bear with me. If anyone is struggling to hear me or anything, just use the chat box, which hopefully along the bottom part of your screen, there's a little text box icon with chat. You can just pop that up and type away if you do want to say anything. There's myself and one of my colleagues from the branch, Suzanne, who's branch secretary, who's administering proceedings, but I'm not going to be monitoring the chat box throughout. So if you do have a question rather than a comment, it would be really useful if you could just put question in big, bold, well, capital letters probably. And then I'll do my best to answer any questions towards the end as we go through. First of all, I should actually have introduced myself. My name is Julie Temple and I am co-chair of the Essex and Ipswich branch, but I am also a partner and head of the employment team at Birkett Long in Colchester. So I am going to be talking to you today just about life after furlough and the HR challenges that you might be facing in that situation. So let me just see if I can get the screen share working properly. Now, hopefully you will be able to see what is on my screen, which means I've now lost where the chat is, so I can't quite see if anyone's told me that they've got it. So if anyone could just say yes, you can see my screen, that would be fab.
Yeah, you're fine, Julie. It's
brilliant. Okay, thanks, Sharon. I recognise that voice anywhere. Right. Suzanne, would you mind just admitting people for me as they come through, please? Right, so HR and business challenges after furlough. Also, actually, one more health warning. I'm a lone parent this evening, and for those of you who have seen me present previously will be aware that I have 4 children who are likely to arrive at around about 7:15 and 7:45 to 8. Alexa is in charge of their bedtimes, so we'll see how well behaved they are. I'm not going to count my chickens, I'll be honest, and I suspect they'll still be up at about 9 o'clock. Anyway, so health warning. I've managed to get away from giving sort of the warning about checking what's going on in the world of government and legislation and updates to guidance of late, but we are now into uncharted territory again with the job support scheme. So just a little health warning that this is up to date as at around about probably about 11 o'clock last night, although I did check to see if any guidance on the job support scheme had been released today, and to the very best of my knowledge it hasn't. So just bear that in mind. Obviously we are in a situation where things are constantly changing, particularly in relation to the financial support being offered currently. So do, as I say, bear that in mind. So in terms of HR and business challenges after furlough, my best representation is on the screen there, and I suspect many of you feel a lot like I do, that the goalposts do feel like they are constantly changing, and personally I feel like there's quite a few goalposts that are constantly changing. So that's my visual representation of life as I feel like I know it. And I'm well, whether you share that view or not, hopefully you'll feel like you're not alone. So moving quickly on, if we just do a quick resume of the furlough scheme, we are in the last month, as I'm sure all of you will know, we are in the last month of the furlough scheme. So currently employers are having to pay 20% of employees' wages whilst they are on full furlough, and also having to pay employer national insurance and pension contributions, with the government topping that up by 60%, so that any individual who is on full-time furlough is receiving 80% in total. Now, of course, there is and has been the ability for there to be flexible furlough from July, and I'm sure that those of you who've been making use of the furlough scheme will be fully aware of the intricacies of that. Now, the big point to note is that the last date by which you can bring a claim under the furlough scheme is the 30th of November. So if you do still have individuals who are on furlough and you're making use of that up until the 31st of October, then the last date that you can make any claim under the furlough scheme is the 30th of November. So as I say, it's an important date for you to note. Now, moving on to the job support scheme. Now, this was released, I think, on the 24th of September. Chancellor gave the announcement about the new financial support that was being put in place for post-furlough and the post-furlough workplace. My summary is on screen. Now, as I had alluded to earlier, I had anticipated the guidance, actually, I think 24th was a Thursday, I think, from memory. I'd anticipated the guidance to come out quite quickly, so I was expecting a glass of wine on the 25th in the evening whilst I mulled over the finer details. But to the best of my knowledge, we still do not have the more detailed guidance to accompany the job support scheme. That said, there is a fact sheet that has been released both on the sort of the first part of the job support scheme, as well as the job support scheme for businesses that are required to close as part of any regional lockdown, and I will come on to that in a moment. But as I say, this is the first announcement from the Chancellor on the 24th of September, and it is in relation to jobs, or it is to support jobs that are viable. Now, we don't yet know what viable means, but certainly my best guess is that it is jobs that are seen as needed by the business in the longer term, but where there is a reduction in work such that there isn't enough for the individual to work full time. And as you can see from the right-hand side of the screen, there is a requirement for any individual who is, or whose employer is making use of the job support scheme, to work at least 33% of their hours for the first 3 months of the scheme, which brings me neatly onto the second point on the slide there, which is the scheme, as I mentioned, is kicking in from the end of the furlough scheme. So the furlough scheme is ending on the 31st of October, and the job support scheme is kicking in from the 1st of November. And it is going to last for at least 6 months, so through to the end of April, with certain conditions we know are going to be reviewed after 3 months. One of those conditions is the requirement to work a minimum of 33% of the hours. Now, the idea behind the job support scheme is that employers, as with the flexible furlough scheme currently, will pay for the hours that are being worked by the individual, a minimum of a third, and then the government, the employer and the employee split the wages for the non-worked part. Now, this caused a little bit of a headache, I know, amongst a number of people, including myself and the team at Birkett Long, when the announcement was first made. But hopefully, when I come on and show you my very high-tech diagram, it will explain it a little bit more and the maths that sits behind it. The government cap is going to, the government contribution is going to be capped at £697.92 per month. I have some views as to whether or not that is a maximum, and actually the more that the individual works, that contribution from the government will become less. That's certainly my anticipation of how it is expected to work, or how it will work in practice, but we'll have to wait and see what the guidance says in relation to that. As is currently the case, as we've moved into kind of the contributions from the employer under the furlough scheme, the employer is going to have to pay and to meet the national insurance and pension contributions. It is available to employers and employees who have not made use of the job retention scheme, so the furlough scheme as is, but the individuals have to have been employed on or before the 23rd of September, and a real-time information return to HMRC has to have been made before that date. As we all know, with the furlough scheme, the intention behind that is to minimise the risk of fraud, and it's deliberately that date because it's the date before the Chancellor made his announcement on the scheme. Mentioned already, minimum of 33% of working time for the first 3 months. I do believe that means it is 33% each week as a minimum throughout November, December and January, being the first 3 months of the job support scheme. There is a slight grey area over that because the job support scheme fact sheet refers to cycling on and off the scheme. I think that refers to a situation where the employee is working 100% of the time and therefore there is no contribution to be made, rather than the employee working 0% and therefore there having to be a greater contribution. My personal view is it's a minimum of 33% throughout all of November, December and January. Also, because it is to support viable jobs, then the individual cannot be made redundant whilst the job support scheme is being accessed, and they can also not be on notice of redundancy. And as I'm sure all of you, if not most of you, if not all of you know, certainly under the furlough scheme, it is possible to put individuals on notice of redundancy and still benefit from the contribution of the government under the furlough scheme. That is not the case with the job support scheme. It is to support viable jobs, and therefore it rules out the ability to claim any contribution towards wages for individuals who are made redundant or on notice of redundancy. Now, just to circle back a little bit, many of you, I suspect, will have had some discussions with individuals within your businesses, or indeed be advising businesses about potential redundancies. Some of you may even have made... Hello. Good night, sweetheart. Good night. Okay, good. So go and do your teeth, please. Good night. Teeth. Yes, so many of you may have already given notice, and if that is the case, then you are going to have to think about, if you want to make use of the job support scheme for these individuals, you will have to think about how you might agree with the individual to withdraw the notice that you've already given. And just as a small matter of technicality, it's not something that you can do unilaterally. So you cannot go to the individual and say, as a business, we are withdrawing your notice of redundancy. That is something that you have to do by agreement. So if you're planning to use the job support scheme to support individuals who have already been given notice of redundancy, then you will have to think about the mechanics of doing that so that it's there, withdrawn, ready for them to start on the 1st of November. Also, just as with the situation under the furlough scheme, the arrangements that the reduced time working arrangements, which in effect is what the job support scheme is there to support, have to be agreed in writing, and that's a simple, well, you have to agree them and give notice to the individual in writing. And as with the furlough scheme, I would very strongly suggest that you get a signature on a piece of paper or a confirmation by way of email or something equivalent, and that you have that on file somewhere so that you can refer back to that if you need to. We'll have to see if there's any further mechanics that are required under the guidance. Good girl. Right, teeth, dressed, bed, and toilet. Right, that's 3 of them done. One left at around about 8:15. So also the job support scheme is going to be open for small and medium businesses regardless, but there is going to be an additional qualification for large businesses. We do not yet know what a large business is, but I will come back to that point when I discuss the lockdown, the job support scheme for lockdown areas, as we might have an indication of what large businesses mean from that. But what we do know currently is that large business is going to have to satisfy some sort of financial assessment, demonstrate that there has been some sort of financial loss as a consequence of the COVID-19 situation. As I say, quite what that will look like, quite what a large business is going to be defined as, we'll have to wait and see. So if we just move into my very high-tech diagram, as I say, when the Chancellor's announcement was made on the 24th, there was quite a lot of head scratching, certainly within my office, mostly by me. But as you can see, top left in yellow, you've got a third working time, which is met by the employer. And if we assume that the individual is working a third of the hours just for these purposes, then there is 2/3 of their hours not worked, and therefore in theory 2/3 of pay not being paid. However, the government is saying that 1/3 of that 2/3, which I can assure you is 22.2% recurring, is going to be met and split between the government, the employer, and the employee. So in that particular instance, where you've got 33% working time, 22% being paid by the employer, broadly speaking, totals 55.5%. Government is paying 22.2%, capped at £697.92, and the employee 22.2% as well, which totals around about 77%. There we go, off we go. And that is where we get to the more finessed Treasury infographic. So you've got 77% of pay being paid to employees who are working a minimum of 33%, 55% by the employer, 22% by government, with the employer also paying the national insurance and pension as well. Now, if we move forward and just have a look at how that works out for individuals working different amounts of time, The fact sheet actually does give you a graph, and I've reproduced that in the notes that come with the session this evening, and I'll show the link for that towards the end. As you can see, you've got left-hand side individual working a third, and then you've got the 22% that follows through up the graph there. Working 50%, then the contribution from the government goes down to 16.67%. Now, as I say, what I don't know is whether or not the cap for 22% is the 697, and it's still 697 for 16%, and it's still 697 for 11%. My feeling is the government contribution and the cap is going to be pro rata to the percentage contribution that they have to make, but I don't know whether that's going to be the case or not, and we're going to have to wait for the guidance. But my money is that the government contribution and the cap on it is going to be pro rata. So that's looking at it on an individual basis and how the job support scheme supports an individual as the percentage of their time goes up, and also what the employer has to pay. If we look at it on the basis of a role, when I first heard about the job support scheme, the obvious approach for businesses where there is one role or a number of people occupying the same role, but actually perhaps there's only one full-time role and 3 individuals who are carrying out that role, would be to say, okay, right, we'll split that role amongst the 3 of you. We can keep you all on, assuming in the longer term they're viable and you feel you might need all 3 employees into the future, and you allow them each to do a third of the role throughout the week. But if you look at the graph, so you've got the 3 employees towards the left-hand side, and then on the right-hand side is the cost. So to get 100% of the role covered, obviously the employer has to pay 100% because each of the employees are working 33.3%. You also then have to pay the 22.2% to each of the employees, which, assuming PowerPoint and the Excel's done the maths right, is 66.67%. Government's paying that, and then each of the individuals are splitting the 66.7, they're foregoing that portion. Now, I'm no maths genius, as anyone who knows me is very much aware, but to me that maths doesn't add up. And the job support scheme, for my money, certainly doesn't work in the way that I was hoping it might work to retain as many individuals as is possible. Now, if you were to go to 50-50, then, if I can bring it back, you would be paying 50, where you'd be paying 100%, and then around about 30 odd % on top of that. I think someone might have just taken themselves off mute. If I could just ask you to make sure you are all muted, just so that we don't get any background noise, if that's possible, that would be great. So that's the job support scheme as announced on the 24th of September. I will have a look at the chat box and look at see if I can answer any questions, but I'll do that at the end, because I just want to whistle through some other bits and pieces and look at some other challenges. We then move on to the job support scheme, the extension of the job support scheme that the Chancellor announced, I think Thursday last week. And again, there's a fact sheet that accompanies the extended job support scheme. The details are on the screen there in summary. So this is in effect a furlough scheme, works in a very similar way, I'm anticipating, to the furlough scheme that we currently have in place. And it applies to support businesses and employees of those businesses who are legally required to close as a consequence of a government rather than a local authority, a government requirement to close, I should say local authority or Department of Health. So it's not as wide-ranging as you might think. It is where there is a legal requirement to close. So, for example, in Liverpool, I think if I've understood correctly, Liverpool pubs, etc., in Liverpool are going to be, certain areas of Liverpool are going to be required to close. That's fine. This would apply to them. If, however, in other areas of Liverpool, individuals aren't going out, as you might expect, so the business falls off for other areas, they've not been legally required to close, and this isn't going to apply to them. The job support scheme will apply, as we've just gone through, from the 1st of November. So again, I having spoken to a number of clients in recent weeks, you know, there's a big gap potentially in the financial support that is being offered, but that's my personal view, and certainly not sort of intended to be political. The other requirement is the requirement to close must result in an instruction and cessation of work of a minimum of 7 days. So I think Liverpool's going to shut down, as an example, for 4 weeks at least. So we've got a situation where that might apply in Liverpool. Also, under this extended scheme, then employers, as with the job support scheme and as is currently the case with the furlough scheme as we move towards the end, employers are going to have to pay national insurance and pension contributions. The government contribution is going to be 2/3 of the normal wages, as we're familiar with under the current calculation of normal wages with the furlough scheme, but capped at £2,100 per month. And as you can see there, and this is the same for the job support scheme, as we've just discussed, the payments are going to be made in arrears. So businesses are going to have to make the payments to their employees and then make the claim, and the government is going to repay. So you've got a potentially cash flow issue. Same requirement to be employed on or before the 23rd of September, and again, doesn't have to have neither the business nor the employee need to have made use of the furlough scheme. Same point in terms of not being made redundant or on notice of redundancy, and the same point about agreeing arrangements and notifying those arrangements to the individual in writing. Now, I mentioned earlier that we might have an indication as to what a large business is for the purposes of the job support scheme as first announced, and I stupidly haven't put it on the slide, so let me just find a bit in my notes. So a small business, and I'll just tell you what the definitions of small, medium and large are for current purposes. A small business is a business that has properties worth less than £15,000. Medium business, properties worth between 15 and 51,000, and then large businesses, properties worth £51,000 or more. Now, the significance of that is that the Chancellor, as part of this extended job support scheme, has announced that small businesses are going to get £1,300 per month. Medium businesses will get £2,000 per month, and large businesses will get £3,000 per month. And these are, in effect, grants that are not, I emphasise, not going to have to be repaid. So for every business who's required to close, they will get £1,300 small business, 2,000 medium, and 3,000 large. Now, if my memory is serving me correctly, that's going to be paid in two weekly tranches. So every 2 weeks you will get a payment if you are a business that is required to close. And as I say, you do not have to repay that. So watch this space really in terms of the guidance around the job support scheme. I'm really quite surprised that we haven't got the guidance out on that to date, because I'm very much expecting it to look and feel in a very similar way in terms of the requirements and the detail that sits around it, similar to the furlough scheme, the job retention scheme. But thinking about it, maybe government's been waiting to announce the extended job support scheme before they give the guidance around everything else. But time will tell. I'm going to put another bet on and say that we'll get that detail probably around about 5 o'clock on Friday, and there'll be a scurry of activity, but we'll see. As I say, I'm quite surprised we haven't had it as yet. Now, there is also the job retention bonus. The guidance, the detailed guidance was released last week, and also the Treasury Directive has come out on the job retention bonus. I don't have any details on the slides, but broadly speaking, for any business that has used the furlough scheme for an individual who is still employed in January 2021, they will be able to claim a one-off payment, not to be repaid, of £1,000 per employee. So in terms of weighing up the benefits or the cost / benefits of supporting an individual on the job support scheme, and weighing in the £1,000 that you might get when it's paid out next year, that's obviously something that you can think about. But you also need to think about the fact that you've already made various contributions to support the employee's wages through the furlough scheme and the job retention scheme. So just do bear that in mind. The details are in the notes about the job retention bonus, and there's some sensible points around what you need to do to make sure that you will be able to claim that when the opportunity comes round. So just on the screen in front of you is a quick resume of the Prime Minister's announcement on the 22nd of September. Now, I'm sure many of you will have been, as we were, in the process of encouraging individuals to start to return to workplaces. One, so that they could refamiliarise themselves. Two, so that they could carry out work that hadn't otherwise been able to carry out, and perhaps catch up on a few bits and pieces. But of course, 22nd of September, Prime Minister announced that individuals, where possible, office workers who can work effectively from home, should be effectively working from home. So a couple of points just around that. The first one is stating the obvious, I think, which is the announcement on the 22nd of September is not the same situation as the announcement on the 23rd of March, i.e. work from home where it is possible. There is a degree of latitude and reasonableness, and more importantly, effectiveness, and a judgment call and balance as to whether individuals should be working from home, or indeed should be working from the office. And certainly my experience is there's, on both sides, actually, employers and employees, there's a degree of balancing and sensibleness that is coming into that equation. And certainly for my part, for example, I'm working in the office primarily to introduce a new member of the team, but from next week I'm going to be starting to reduce the time that I'm personally in the office, and the team around has reduced their time in the office following the announcement on the 22nd of September. And I expect that approach is being mirrored across a lot of office-based employers since that date. And we are expecting that situation to remain the status quo through to April or so next year. So through the winter months and through what we're anticipating to be a potential peak. And ultimately it will be a question of discussing and considering between the employer and the employee about whether they can work from home. But there's certainly things, you know, personal situations, what work needs to be done on any given day, etc., that you're going to have to take into account. Things like children and bedtimes might be something that people might want to think about for future. She says with a slight tongue-in-cheek. So that's kind of bringing us up to date. That's a whole series of things that I wasn't necessarily expecting to be talking about today when we put this event into the diary. But of course, things are moving. And as I say, opportune moment just to remind you that everything that I'm talking about today is up to date as at around about 11 o'clock last night, albeit, as I say, I have checked that there's been no guidance in the interim. But if anyone does see the job support guidance coming out, then if you feel free to let me know, that would be great. So we move on. Just a quick kind of overview of the past 6 months or so. It feels like a long time ago since we were talking about closing of schools, etc. And you know, we've kind of moved through the various stages that I've expressed on the screen there. And more recently, we've had the announcement on the 22nd of September with office-based workers to be working from home where they may effectively do so. Now, as a consequence of everything that's been going on, there's a whole host of challenges that I can envisage business and HR in particular playing their role in managing. One key approach to all of these things is going to be communication. And I did a presentation for I think both this branch and East London branch around managing mental health, and we were talking about the importance of communication and the fact that if individuals aren't told something, if they're not given information, we are predisposed to be negative. So as part of your communication strategy as an employer, coming out from HR and what the future might hold, do bear that in mind. And if you are able to offer reassurances as far as you can, obviously not being able to offer guarantees because we just don't know what's around the corner, but as far as you can, if you can give reassurances around what the business might be thinking about, who might be impacted, then I think that's going to go a long way around managing and helping individuals' mental health as things are changing on such a kind of daily basis, and certainly as the news appears to be worsening. So number of things there on the screen in terms of potential challenges. I mean, the return to the workplace and the commute, perhaps less of an issue currently, but fast forward to perhaps March, April time, these are things that are going to have to start to be thought about. I'm going to primarily focus for the rest of this presentation just around restructure and redundancies and adjusted working, which links in with the job support scheme, which, as I mentioned earlier, is broadly speaking a short time working support scheme. Now, restructures, I've said this a number of times throughout the current situation, and it's something that I think it is always worth reminding businesses that actually, of course, there is a financial calculation to be carried out, and of course the books have to balance and we have to be able to meet our outgoings, but ultimately individuals, your employees, are going to be your best ability to bounce back as things start to turn a corner. So I would urge you to think about alternatives to redundancy, if there are any, but also to think about and weigh into that calculation the fact that potentially if you let people go now, make people redundant, then you might have to recruit in the future. What are the costs of that going to be? Also, you've got to factor in an ability to recruit. And if you are thinking about recruiting, say in April next year, and perhaps with the other side, then you will be fighting potentially with businesses in a similar sector to you who are also recruiting at the same time, and you're going to have to think about how you're going to sort of make you the preferential employer, the employer of choice to individuals who might be being recruited at that time. Now, of course, other thing is whether or not you've got a temporary downturn in work or it's a permanent downturn in work. If it's permanent, the job support scheme is unlikely to support you because that's for viable jobs. And in my view, that's going to be a situation where there's a temporary downturn and ultimately there's an expectation that that reduction is going to be temporary and bounce back and return in the future. Now, of course, if you've benefited from efficiencies within the lockdown period, increased use of technology, a change in the way that you're working, then you might find that there are some permanent reductions in the type of work that you're needing to be carried out. So unfortunately, even with the job support scheme there, you might have to consider the possibility of redundancies, but do think about both the kind of the human cost, the ability of the business to bounce back and to meet demands as those demands start to return, as well as the financial side and what's the maths behind using furlough, behind using the job support scheme. Now, I'm not going to talk through the entire redundancy or a best practice redundancy process, but on the screen there is an outline of the stages in a best practice redundancy process, and I'm just going to pick out a couple of them to sort of focus on some points where certainly myself, either acting for the individual or acting for the employer, where we tend to focus the majority of our time to try and make sure that the process is as good and as robust and as reasonable as it can be. So the first one inevitably is there a redundancy situation at all? Now, that arises legally in 3 situations. So that will be where the business is closing entirely, where the business is closing at the location where an individual is employed, or where there is a reduction in the work of a particular type that the individual is employed to do. So there's the 3 legal situations in which a redundancy might arise. And if you have any one of those 3 situations, I suspect for most of you, if you're thinking about that as part of the challenge post-furlough, then the chances are you're looking at a reduction in a particular type of work. Now, from there, preparation is inevitably key, and I would strongly advise that you are documenting any decisions that you're taking at the preparation stage. It's a couple of things for you to particularly watch out for. First of all is checking to make sure or making sure you're including within any group of individuals that you're going to have to consult with about redundancy anyone who is off sick, be it short-term or long-term, anybody who might be on a sabbatical, long-term leave or something like that, anyone who's on maternity leave, because they all have to be included as part of the consultation exercise if they are part of the pool that is being impacted. If you do have a pool, so if you have, let's take me as an example, you have 3 employment law solicitors within your business, and if for example, you decide actually there's only enough work for two, then you potentially have a situation where all three solicitors have to be put in the pool, and you have to decide how you are going to choose the individual who might be the person who exits on the basis of redundancy. Now, it's not quite as simple as that, because you might have different levels of employment solicitor. So you might have a solicitor, a senior associate, and a partner, and actually you might decide that you need a lower level who can do work at lower rates, and you need the higher level who can supervise, etc., etc. So you might say the middle level goes, or you might say actually the work we've got is higher level, so therefore it's the lower level that goes. But they're the sorts of decisions that you will need to be thinking about, and you will need to document why, so that ultimately, if you do find yourself in the situation of an individual challenging the decision that's been made in respect of them, you've got the paperwork there. You're not having to go back and remember, oh, crumbs, what did we decide on the whatever date we are, 13th of October, as to why we were going to target a junior solicitor as opposed to a senior associate, and that type of thing. In terms of criteria, always best to think about what you can test objectively. So, for example, again using me, we won't surprise you, have targets, and you can use performance against targets. You can use, if, for example, there have been complaints made against individuals, if individuals have got a disciplinary record, timekeeping, although you do need to be careful about using timekeeping and indeed absences if that relates to potentially a disability, for example.
Mummy,
Hello,
can you please be a bit quieter, because I can hear you in
okay.
there and my sisters can't hear you.
Okay, I'm going to try and speak quieter, okay?
And then I'm getting most of the noise.
Okay, I understand. Off you go. I will speak quieter.
Are you reading that?
No, I'm not. Good night. Sorry, I have to try and speak a little bit quieter now. So yeah, think about things like absence records, if there's any potential for there to be a discrimination angle that somebody might be able to argue in the future. Length of service is something that you can use, albeit that it does potentially indirectly link to age, as long as it is not the sole criteria and it's part of a mix of criteria that you're using to score individuals on. Just briefly on collective consultation, it is important that very early on in the process and as part of the preparation, you are thinking about how many people are potentially impacted and over what period. If you are looking at potentially making redundancies of 20 or more within a 90-day period, then you will have to go through the collective consultation process, which might mean that you need to elect representatives, and it might mean that you've got a minimum 30-day consultation period if you are talking about 20 or more, and if you're talking about 100 or more, then it's a 45-day consultation period. So you do need to factor that into your process. On the screen there, you'll see you've got the scoring. So if you do have a pool, then it's important that you carry out the scoring. Individuals are only entitled to see the scoring for themselves. They're not entitled as part of the consultation period and the process to see other people's scores. You might, as part of that process, want to say, well, the score that you've got to be would be X, Y, Z, particularly if they're somewhere away from that score. Now, I would encourage you as a business to be as open as possible about the reasons for any redundancy, and that will follow through the process from a group meeting, by which I mean first saying to the employees, and now it might be just one individual, these are the reasons why we're contemplating removing your role or closing this part of the business down. And that you follow that through consistently through the first letter which confirms that they're at risk, and then your subsequent meetings with them. Now, just one final point in terms of what's on the screen there, and I'm just picking out different points, is appeal. I've seen quite a lot of debate online as to whether or not individuals are, strictly speaking, entitled to a right of appeal. Frankly, whether they are or not is neither here nor there. My view is, as a business, you should offer a right of appeal, not least because it's an opportunity for you as a business to assess if the individual has a strong basis to challenge the decision that you've made to make them redundant. And as I say, I would always urge you to allow a right of appeal in those circumstances. So that's redundancy and an overview of the process. As always, within the notes, there's some further details there for you to read through and have a look through. And just seeing one point there, in terms of collective consultation, if you are having to go through collective consultation, if there is any doubt as to whether you need to collectively consult or not, I would, funnily enough, we're discussing this today, always err on the side of caution and submit your HR1 form to the Secretary of State. You are best to do that rather than not, because if the collective consultation obligations apply and you haven't done your HR1 form notification to the Secretary of State, you're committing a criminal offence. So as I say, you're best to err on the side of caution and submit it, even if you didn't need to, rather than be on the other side and you should have done but haven't. So as I say, err on the side of caution there, and just make sure you don't end up in difficulties. So moving on to look at changing contract terms, and this quite neatly links in with the job support scheme and the fact that the job support scheme is there, but of course it's to support reduced working hours of a minimum of 33%. Now, unless you do have a layoff and short-time working clause within your contract, then you're not going to be able to go to employees and say, you will be working for this amount of time from the 1st of November. And as a consequence of that, we're going to be making use of the job support scheme, and therefore your salary is going to be X, Y, Z. You will need to discuss and agree that change with them. So if we follow through what you've got on the screen there, you've got the terms of the contract is going to be the starting point for any change to terms and conditions of employment that you want to make. If you have the right to make that change under the contract, then I would always urge you to still approach it on the basis of discussion and consultation with the individuals, and then to notify if you need to that you're exercising your right under the contract. Ultimately, we are all in a situation where we've got a tough enough job at the moment as it is. To add to that some disgruntled employees who aren't necessarily happy that they've been told they're going to work reduced hours and they've not necessarily been consulted with, is just going to add to your workload. It is far better, in my view, even if you have the contractual right to do it, by all means tell them you've got the contractual right to do it a little bit down the line, but have the conversation, explain the reasons. Hopefully that won't take much, because it's a global situation that we are in. We are all experiencing things in different ways. We're all suffering in our own ways, if that's the right expression, facing our own challenges. And I hope that individuals are in a situation that they clearly understand, and hopefully understand that the business itself is suffering financially as well, and indeed, potentially hasn't got the work there either. So I would encourage you to think of it from that perspective. If, however, you haven't got the contractual right to do it, then you can follow a similar process to the redundancy process we've just outlined. You meet with the individuals, you discuss the change that you want to make. you discuss the reasons why you want to make that change, and hopefully, particularly with the support of the job support scheme, if you can financially afford to do that, and I will just pick up on that point in a moment, you know, hopefully you'll be able to encourage the individuals to agree to the changes that you want them to make. The alternatives, I will be honest, are not appealing, particularly if you do have employees who have 2 or more years service, and the same applies for redundancy, because the risk there is far greater, as they have the right to bring a claim for unfair dismissal. Now, there are exceptions to that rule, of course, but if you do have individuals who have that unfair dismissal protection, you really do need to be far more cautious. And if in a redundancy situation you've got an employee with less than 2 years service, actually you don't necessarily need to follow any of that process unless you think there's a particular risk. You can, you know, if you're minded to, simply go to the individual and say, you know, I'm afraid we're in this situation, we're giving you notice. You don't necessarily need to go through that consultation process. But returning to changing terms and conditions, if you're not able to reach an agreement, you have 3 alternatives really. The third isn't on the screen there, but one alternative is you leave things as is, which I'm going to assume for the purposes of this isn't a viable option. And I mean that differently from the job support scheme, because we don't know what that means yet. But otherwise, you've got the option to dismiss. That's going to be, stating the obvious, a dismissal for the purposes of unfair dismissal. So you need to have a reason and you need to have followed a process, but you put forward an offer of employment on the terms that you want the individuals to work under. Now, they may accept, they may not. If they thought you were bluffing and they were going to accept anyway, then they'll probably accept at that point, but it's a risk. And it's not one to be taken lightly, and I'd certainly urge you to take advice if you have employees in that situation, particularly if they have 2 years or more service. The other alternative is that you impose the change. So let's say, for example, you are asking, and a number of my clients have successfully agreed to this, you're asking employees to work their normal hours, so let's say it's 5 days a week, but actually you can only afford to pay them for 4. So you're saying, right, we want you to work 5 days a week, but we're going to pay you 4/5 of your salary, ignoring the job support scheme for the moment. Imposing that change would be allowing the employee to come in and work 5 days, but at the end of the month, or 4 weekly cycle, whatever it is that you pay the individuals, you pay them 4/5 of their pay. Now, the risk there is that you've made an unlawful deduction from wages, and that they resign potentially, or indeed they continue to work for you, but they're accruing their losses, and that they might bring a claim against you in the future. So you might have a situation where you have an employee who's bringing an employment tribunal against you for the non-payment of wages when you've been paying them for 4/5 when they haven't agreed. All right. Now, just circling back to the job support scheme for a moment, and in the context of this discussion, I'll move into layoff and short-time working briefly in a moment. I do not believe that there is going to be an obligation on businesses to use the job support scheme. This said, and as I said at the very beginning, when the coronavirus job retention scheme, furlough scheme, was introduced, if you are looking at short-time working, layoffs, or indeed redundancies, if you do not consider the availability of the financial support that is available, so the job support scheme, the grants that are going to be available, etc. If you don't do that balancing exercise, that calculation, and you simply say we're not going to use it, then you are going to be in a situation of risk so far as unfair dismissal is concerned. And potentially, if you, I know a number of clients have already agreed short-time working arrangements, because the job support scheme was announced relatively late, and after collective consultation processes had to have been undertaken to end when the furlough scheme ended, you still potentially need to go back and look at the impact of the job support scheme and if it's something you can financially make use of, because again, otherwise individuals might come to you and say, well, you're not behaving in a reasonable way and therefore I'm going to leave. That's worst case scenario. I personally feel that risk is relatively small, not least because individuals, ultimately the alternatives, at least if they are employed, however, under whatever arrangement, they are guaranteed some sort of salary, whereas if they resign, they're going to have to take their chances. But I want to flag that to you, but as I say, I genuinely do not think there is going to be any obligation imposed on business to use the job support scheme. But if you make a decision not to use it in particular cases, as I say, document that so that you've got that to go back to in the future if you need to. Now, briefly in relation to layoff and short-time working, it is worth mentioning this, not least because perhaps the job support scheme is quite a heavy financial obligation on businesses. As I say, I don't think there's any reason why you couldn't opt to exercise a right under a contract to implement short-time working and to pay accordingly, rather than to rely on the job support scheme with the health warning I've just given. Now, under the statutory layoff and short-time working arrangements, layoff, I've had to dust off my notes from the beginning of lockdown for this. It's quite a complicated process, particularly in terms of what entitlements come out of the other end. But briefly, a layoff under the statutory scheme is where an individual is laid off for a week, so there is no work and no pay. And short-time working is where they receive less than half a week's pay in any particular week. Now, under that situation, there is a guarantee payment if the individuals are eligible, and that is for 5 workless days in a 3-month period. So it's not a huge amount, and it certainly isn't going to be comparable to the support under the job support scheme. And so you can see the definition of a workless day there, which is where there's a reduction of the work in the that the employee is required to do, or there's some sort of disruption to the type of work. Now, as I say, there is an entitlement to claim for redundancy in a layoff and short-time working situation, and that is where there is either a layoff or short-time working, or a mix of the two, that persists for 4 or more consecutive weeks, or 6 weeks within a 13-week period, of which 3 have to be consecutive. So, as I say, quite a complex arrangement in terms of notice, counter notice, to be entitled to claim notice. So do have a think about, have a look through the notes if you are thinking about availing yourself of that, either as part of the job support scheme or as an alternative. Now, also in the notes, I have just included some details around flexible working. Now, again, that's moved on a little bit under the current arrangements, in the sense that the more that we're pushing back potentially a return to offices, certainly for individuals, the less likely it is that you're going to get an influx of the flexible working requests. But the information is there if you are starting to see that trend. So please do have a look. Now, hopefully, yeah, I've got on the screen there, you will see a link to the branches survey for the event today. I will post these links into the chat box once I've finished speaking and we start to look at the questions. Also, we have got a couple of events posted, or one event is posted, which is the annual event on wellbeing for HR. It is currently sold out, but I'm going to go on bended knee to Wimbledon and see if we can beg, borrow, and if necessary, steal the increased Zoom license so that we can have up to 500 attendees to that. So once I've begged, stolen, borrowed that, we will announce on through the LinkedIn and Facebook that the number of available spaces has increased. So do watch out for that, and Suzanne will no doubt include that as part of the newsletter as well. So if you don't receive, if you're not part of any of those, or at least one of them, then do follow us on LinkedIn, etc., and we can you'll get the updates as they happen. Finally, a link to the notes there. You will see first of all the link, and as I say, I'll post that in the chat box in a moment, and then the password there as well, just so that you can get access. Just copy and paste that from the chat box, and you'll be able to download those direct from the Birkett Long website. Okay, so questions. I'm going to leave my contact details up on the screen, and I'm going to see if I can find the chat box so that we can work through those. Obviously, in the meantime, if anyone does want to ask any questions, feel free. I'm perfectly happy if you do want to get in touch with me after today and ask a question that's perhaps a little bit more sensitive and you don't want to deal with it now. Perfectly happy for you to get in touch with me, or indeed any of the Birkett Long employment team if you wish. So one of my clients would like to enforce employees to take holiday during the job support scheme on the days they do not work but receive the money through the government. This will require notice, but do you think they will be able to do this and top up the pay to 100%? Now, my view on that is influenced by what has been happening under the flexible furlough scheme, and it is clear under the flexible furlough scheme that individuals can take holiday during, in effect, what are furlough days, as long as they haven't been deliberately put onto furlough in order to take holiday. So, for example, someone works 5 days a week. Under flexible furlough, they work 3. They can be required to take a day or 2 days during their non-working furlough days, and that's how it has been working under the furlough scheme. I don't think that's going to change under the job support scheme. That's my instinct. Whether that is the case or not, I don't know. We'll have to watch this space for the guidance on that. But I genuinely don't see the government taking a different approach to that. So hopefully, Megan, that helps with that. You have asked a technical question around usual wages. The best that I can do for you, I'm afraid, is point you in direction of the coronavirus job retention guidance, which deals with what is included within the calculation of usual wages, because I can't remember it off the top of my head. And at that point, I generally push individuals in the direction of the guidance and or their payroll providers or individuals responsible for that. So I'm sorry I can't particularly answer that question. So, is there a successful fire and rehire case? Well, I'm not aware of any specific fire and rehire cases, but I guess we are going to find a whole wealth of situations where individuals have been dismissed in the run-up to the end of the 31st of October, and perhaps businesses are looking to reconsider those decisions as we are moving through to the 1st of November. But I don't know. We will have to see. So Victoria has asked, how do you think holiday should be calculated for anyone on the job support scheme where they are working various hours? So my view on that, again influenced by the flexi furlough scheme and the experience that we've had with that, is I think we are going to find the same situation. The holiday should be paid based on normal wages, so non-furlough, non-job support scheme wages, which will mean that there will be the holiday days, whether they're working days under the job support scheme or non-working furlough days under the job support scheme, will have to be paid at 100%. So, for example, paid £25 a day, just off the top of my head. I can't extrapolate the maths, but they will have to be paid £25 a day for the holiday, albeit that they might be paid less under the job support scheme for their working days. So hopefully, Victoria, that makes sense. So Stacey has asked about COVID and the backlog in employment tribunal cases. Well, I have to say that there isn't quite the backlog that I have been anticipating, and we as a team, we're probably acting on around 30 or 40 employment tribunal cases at the moment, and they are actually coming through surprisingly quickly, which I'll whisper quite quietly. As to whether it will deter employees, it may well do, and certainly as an employer, if you are exploring the possibility of settlement, then certainly at the ACAS stage and the ACAS early conciliation stage, it is worth mentioning the fact that they might be facing hearings in 2021 or 2022. We certainly have a number of claims which are listed towards the back end of 2021. I don't think we've got any listed in 2022, but the prospect of waiting for that period of time, it might be something that you can use. And yes, Marco, you're absolutely right. Employers may want to settle because they don't want to have this hanging over their heads. And of course, a big problem where there is a delay in hearings being listed and indeed heard is the possibility that individuals who are crucial to, individuals whose evidence are crucial to the defence of a claim or indeed the pursuit of a claim might move on. Now I appreciate that's possibly less likely in the current situation with the job market as it is, but it is something to bear in mind. So I think, unless I've missed any questions, I think that is, I know Mark, you've just pinged one in, so I will just come back to that. I just want to make sure I haven't missed one. So can you confirm that if making furlough individuals redundant, you can calculate at the 80% rate and ask them to take any holidays due during their notice period? So the second point first, you certainly can ask employees to take holiday during their notice period. So holiday during notice, yes, you can certainly ask them to take holiday. You can require them to take holiday during notice if you've got enough time to give them notice to do it. So if you want them to take a week's holiday, you have to give them 2 weeks notice. If you want them to take a day, you have to give them 2 days notice. In terms of individuals, you can calculate redundancy. Well, it's unclear, Mark, whether you mean redundancy or notice, but in both instances, the redundancy payment and notice, broadly speaking, there's a sort of complex little known bit of the Employment Rights Act in terms of notice. Redundancy should be based on 100% of pay. The notice will depend on whether or not there is a statutory notice period or a contractual notice period, and if the contractual notice period is more than 1 week more than the statutory. I won't try and explain it. If you go to the blog page, which actually is just on the slide there, the bottom link, you'll be able to see one of my colleagues, Reggie Lloyd's article on the notice and whether or not it has to be paid at 100% or not. All right, so on behalf of myself and the other committees, do just thank you for joining us, and stay safe, everybody.